I hope everyone's had a good amount of coffee and pastries. Welcome everyone and good morning. And thank you for attending today's morning seminar titled Spotlight on Hong Kong, Innovations in International Arbitration in this incredibly beautiful salon arranged by Gaillard, Banifatemi, Shelbaya Disputes. My name is Eric Ng. I am the Deputy Secretary General of the Hong Kong International Arbitration Center, and I am honored to moderate this esteemed panel for you today as we discuss some of the key developments in the arbitral landscape in Hong Kong that have contributed to the continued strength of Hong Kong as a seat of arbitration. Our panelists today will provide keen insights into the importance of these developments and views from those who have been on the ground in Hong Kong and Hong Kong-based disputes as to what considerations parties and counsel should have when thinking of an arbitral seat. Let me begin by introducing the panel for you today, starting with, on my far left, is Kim Rooney. Kim is an international arbitrator and Hong Kong barrister at Guild Chambers, sitting as an arbitrator in aviation, commercial, construction, and infrastructure disputes, as well as finance, high technology, and energy. She is a member of the ICC's International Court of Arbitration, the EBRAM International Online Dispute Resolution Center's board, the Hong Kong Bar Association's council, chairing the arbitration committee, and the Rules Committee of the Hague Court of Arbitration in Aviation. She is also the editor of the IBA's Dispute Resolution International. Perhaps most pertinently for today's discussion, she chaired the subcommittee on third-party funding for arbitration for the Hong Kong Law Reform Commission, which allows now for permitting third-party funding of arbitration based on draft legislation annexed to the HKLRC's 2016 third-party funding for arbitration final report. From 2013 to 2016, she was a senior ADR expert in an EU-funded project in the Indonesian public sector, and in 1998 to 1999, she led a World Bank-funded project advising the Ministry of Justice of the Lao PDR on international arbitration law reform. Previously a partner of White & Case, heading its Asian international dispute resolution practice, she is also admitted as an English solicitor and a Western Australian barrister and solicitor. Moving to the next on the list is Wesley Pang, as you see on the panel there. Wesley is a partner in the Global Litigation and Dispute Management Group of Eversheds Sutherland, based in Hong Kong, where he heads the firm's international arbitration practice in Asia. With nearly 15 years of experience in advising private and sovereign clients on commercial and investor state disputes under various institutional rules, he has a particular expertise in the energy sector and infrastructure project disputes in Asia, Europe, the Middle East, and Africa. He worked for several years with Sherman & Sterling, during which he worked on some of the largest, most complex disputes in the world, and also worked with the firm's project development and finance team, advising clients on contentious and non-contentious issues. Prior to joining Eversheds Sutherland, Wesley was actually my predecessor at the Hong Kong International Arbitration Center as managing counsel, where he promoted the use of arbitration in Hong Kong as a venue for dispute resolution across Asia, Africa, Europe, and North America. In his role as managing counsel, Wesley also oversaw the Secretariat's handling of the Center's caseload under all the various HKIAC rules, the UNCITRAL rules, and the Hong Kong Arbitration Ordinance. Wesley is also a member of the HKIAC Reserve Panel of Arbitrators and the KCAB Panel of Arbitrators, and also an adjunct associate professor with the University of Hong Kong. Moving on, to Wesley's right is Mr. Robert Pei. Mr. Robert Pei is an independent arbitrator, a member of arbitration chambers. And he is regularly appointed in arbitrations under the rules of the HKIAC, ICC, ICDR, LCIA, and SIAC, arising out of international commercial disputes, in particular in relation to energy and infrastructure, mergers and acquisitions, shareholder agreements, and sale of goods. He was based in Asia for 2 decades and served on the HKIAC Council from 2014 to 2020, and is also a member of the ICC Court. On Robert's right is Mr. Mohamed Shelbaya, who is a founding partner of Gaillard, Banifatemi, Shelbaya Disputes, recognized as a leading figure in arbitration, with a particular focus on arbitrations in the oil and gas sector. Prior to founding Gaillard, Banifatemi, Shelbaya Disputes, he was a partner at Sherman & Sterling, where he practiced for more than 12 years. Based in Paris, he's represented companies, states, state-owned entities in more than 60 commercial and investment treaty matters, including many multi-billion-dollar disputes involving novel questions of international law and geopolitical issues. Mohamed has secured a number of landmark victories for his clients, including in a recent string of precedent-setting awards on the application of the ICSID Convention and the English law of assignment, which fully dismissed claims exceeding $4 billion that were brought against his client in connection with the operation of an LNG liquefaction plant and associated long-term gas supply agreement. Mohamed also regularly acts as an arbitrator in commercial and investment arbitrations under the rules of the ICC, LCIA, UNCITRAL, and Cairo Center. Mohamed teaches investment arbitrations at the Sciences Po, apologies for my pronunciation, law school. He also serves as a member of the LCIA court and as president of the LCIA Arab Users Councils. Finally, last but not least, on my right is Mr. Benjamin Siino, who is also a founding partner of Gaillard, Banifatemi, Shelbaya Disputes, and prior to founding Gaillard, Banifatemi, Shelbaya Disputes, he was also a partner at Sherman & Sterling, where he practiced for more than 10 years. Benjamin acts as a counsel in ad hoc and institutional arbitrations under UNCITRAL, ICC, and ICSID rules. Experience includes energy arbitrations, investor-state arbitrations, and general commercial arbitration, and many of the matters related to Africa. Benjamin's other area of focus, and which is probably relevant for today's session, is arbitration-related proceedings before national courts. He regularly acts as counsel in proceedings to seek the setting aside, recognition, or enforcement of arbitral awards and foreign judgments before French and other national courts. Most notably, Benjamin was heavily involved is heavily involved in the enforcement of the $50 billion award on behalf of the majority shareholders of the former Yukos oil company against the Russian Federation across multiple jurisdictions. He is also author of several publications in arbitration-related litigation, has co-edited the second edition of the GAR Guide to Challenging and Enforcing Arbitral Awards, acts as team leader to the New York Convention Guide Project, a project undertaken with UNCITRAL in relation to the UNCITRAL Secretariat Guide on the Convention on the Recognition and Enforcement of Arbitral Awards, and also, for today, is also a member of the PAW board. So thank you again to the panel and for today's discussions in relation to developments in Hong Kong. Now, we are split this session into basically two sections, and the first will be in relation to developments of Hong Kong as an arbitration jurisdiction, most notably in relation to developments in its arbitration law, which have happened over the course of the past few years. I will turn the floor over now to Kim, who will talk a little bit about third-party funding and recent developments in outcome-related fee arrangements in Hong Kong, which have now allowed for much improved litigation financing. So Kim, over to you.
Thank you very much, Eric. And may I thank very much the organisers, GBS Disputes and HKIAC, for the opportunity to speak with you all today. And thank you who come in person and are participating online, which we need to remember, for this chance to speak with you about one area of Hong Kong's recent law reforms, and that concerns funding of arbitration. And in the 10 or 15 minutes I have, I'm going to be speaking with you about two key reforms from Hong Kong's perspective. First, the provision to allow third-party funding of arbitration effective February 2019. And second, the very recent reform effective December 2022 to allow lawyers to charge, and it's a long name, outcome-related fee structures for arbitration, also known as success fees and contingency fees. And you may say, well, in my jurisdiction, these forms of funding have been available forever, or at least since the 60s or 70s. However, for Hong Kong, this really is quite a profound shift in the concept of how arbitration may be funded. And I'm going to try and explain why, because that does inform the approach that Hong Kong has taken when formulating these reforms. These reforms followed public consultation and recommendations by the Hong Kong Law Reform Commission through specially constituted subcommittees. As Eric mentioned, I had the honour and the privilege to chair the subcommittee that reviewed the law concerning third-party funding of arbitration, conducted a public consultation process, made recommendations, and prepared draft law. So in this presentation, I will speak with you about why Hong Kong considered these reforms were needed, what the reforms are, and Hong Kong's light touch regulatory approach. And on the regulatory approach side, sometimes people will say from other jurisdictions, why regulate at all beyond whatever the courts may think in specific case-by-case situations. But once again, in the Hong Kong legal cultural scene, this was necessary for these reforms to go through. So may I give you a little bit of background about Hong Kong, and I know many of you know about Hong Kong's legal framework, so forgive me, but perhaps some people are not familiar with it. Hong Kong is a common law jurisdiction. It has a separate legal system from mainland China's civil law system under the one country, two systems principles. Hong Kong's arbitration law is called the Arbitration Ordinance, which you'll be hearing a little bit about, is based on the Untitled model law. Hong Kong's legal profession is still divided between solicitors and barristers. We do not have a fused profession except in arbitration. And in arbitration, though, we have a very open regime. Anyone may represent a party in an arbitration taking place in Hong Kong in the strict sense of arbitration. I'll come back to that. Hence, a party's representative does not have to be legally qualified. So moving on to first, why were these reforms needed? Hong Kong's common law system still includes that plus 700-year-old common law or those plus 700-year-old common law doctrines of championship, maintenance, and barratry, unless they're expressly excluded. Now, I'm not sure if all of you are familiar with those doctrines. You'll be pleased to know I'm not going to read out to you what they are, but I am going to share with you that the effect of these doctrines is that third parties to proceedings are prohibited from funding or profiting from contentious proceedings in which they do not have an interest recognised by law. There are some exceptions, but these didn't seem to work for arbitration. These doctrines still apply to litigation in Hong Kong, save for enforcement proceedings under the Arbitration Ordinance. So the Hong Kong Law Reform Commission recommended that the reforms were needed in two separate briefs or references to ensure that Hong Kong's arbitration framework does reflect best practices internationally to maintain Hong Kong's competitiveness as an international arbitration centre. And we did struggle with this, but we did conclude, yes, indeed, to support access to justice. It's not simply a commercial issue. Now, second, what are these reforms? We were told to limit our slides, so I haven't put up this slide, but I want to share with you first what the common features of the reforms are. And as Eric has briefly mentioned, these reforms allow funding, whether by third-party funders or lawyers, of arbitration, as well as emergency arbitrator proceedings, mediation, and enforcement proceedings in the courts under the Arbitration Ordinance, our arbitration law. They followed review, as I've said, public consultation and recommendations by specially established subcommittees of the Law Reform Commission. Why do I mention this? I believe it did contribute to the quality of these reforms that there was wide public consultation, and we received on a third-party reference submissions from lawyers, from third-party funders, from public interest groups, from individuals, and the vast majority were supportive. There were only a couple of people, and they were individuals who thought it was a bad idea. So we did get community buy-in. Both sets of reforms involve amendments to the Arbitration Ordinance, and both have a degree of regulation. So now may I go on, and you do have the slide up there. Yes, this is to do, first I'm going to talk a little bit more about third-party funding for arbitration. Now, if you recall, at the beginning I said that it was helpful to know the background of Hong Kong's legal regime, that is that championship, maintenance and barratry still apply. Why? Because apart from anything, the way that the reforms for third-party funding have been drafted is by reference to these concepts. And so when we were making recommendations as to the definition of third-party funding, third-party funder, third-party funded party to a funded party, we had to refer back to what the concepts of championship, maintenance and barratry concern. So this may seem very obvious to you, but in Hong Kong, third-party funding is a provision of arbitration funding. You can see it up there, but if I may, I will go through it with you. The provision of arbitration funding for an arbitration and related proceedings under the arbitration ordinance. Remember, I mentioned emergency arbitrated proceedings, mediation, and litigation for enforcement. By a third party, known as the third party funder, under a written funding agreement to a funded party in return for the third party funder receiving a financial benefit only if the arbitration is successful within the meaning of the funding agreement. So it's non-recourse. There are quite a few provisions in this Part A of the arbitration ordinance that was added to flesh out the ideas of third-party funding and what kind of matters need to be regulated. But it was decided, adopting this light-touch regulatory approach, that there should be a code of conduct for a third-party funding of arbitration which applies to all third-party funders who fund arbitrations taking place in Hong Kong. This is whether they're seated in Hong Kong, whether there's no seat but they're taking place in Hong Kong. This code of conduct applies. Now, what kind of areas does this code of conduct cover? May I mention that when we drafted this, we did look at among other materials, the code of conduct that the Association for Litigation Funders in the UK or in England had prepared, an earlier version, because we started doing this work in 2013, 2014. However, we did materially depart from it in a number of respects, taking into account what we thought were the needs of Hong Kong. And as I say, that thought as to what the needs of Hong Kong was informed by the public consultation process. So when you look at that code of practice, you'll see that it expects that there be informed consent by the funded party. The funder has to satisfy capital adequacy requirements. There needs to be management of conflicts of interest provisions. There should be an address for service of third-party funders in Hong Kong. May I say that was one recommendation we did receive a few submissions on from certain sectoral interests saying, why do we have to give you an address for service in Hong Kong? But we just thought it would simplify matters if there was ever any issue between the funder and the funded party. It needs to address control. That is control by the party, notwithstanding that there is third-party funding. Confidentiality, may I mention in passing that Hong Kong, as you know, or may know, does in its arbitration law provide that arbitration is a confidential process, not just in arbitration proceedings, also in the courts. Mandatory disclosure of third-party funding. Majority of public consultation responses we got supported that, and then hence it is required that third-party funding be disclosed in arbitral proceedings, and also the termination of it. Also required is that there be clear grounds for termination of the third-party funding agreement, that there be a complaints and enforcement procedure. It has extraterritorial application in this way that it applies to third-party funders wherever they are if they're funding arbitrations, as I've said, taking place in Hong Kong. What's the effect of breach? Well, no immediate effect. That doesn't strike down the third-party funding agreement automatically. However, breach is a matter that may be referred to if there is a dispute between the funder and the funded party. Now, this is moving really fast, but I know we have a number of more panellists to go to, so may I move on to, I hope I'm moving on to, outcome-related fee structures. Now, many of you are familiar already, I know, with contingency fees and success fees. This was a somewhat controversial proposal, it may surprise you to hear, in the Hong Kong legal profession. And other colleagues may agree with me on this, because I've already shared with you Hong Kong's legal profession is still divided between barristers and solicitors. We haven't had the reforms of our legal system that, for example, England or Wales have had. And there's a fairly traditional approach to what the role of a lawyer is. And so there is a group in the legal profession who are concerned that lawyers have now the potential to commercially benefit from proceedings in addition to getting paid fees. That's one of the reasons, and I should have mentioned this as a reason too for the scope of the third-party funding of arbitration. That's why these reforms are limited at the moment to arbitration unlimited and related proceedings, is to show how it works, whether it can work, and see whether or not over time these reforms may be extended to litigation. Okay, so let's go back to how has Hong Kong approached the structures of these fees? Well, lawyers in Hong Kong may now enter into one of three types of outcome-related fee structures for arbitration, OFSA. The first is a conditional fee agreement, and in this structure, the lawyer is to be paid a success fee, and the reference point is the amount of legal fees, the benchmark fees they would otherwise have charged. And they will get that uplift on the occurrence of a successful outcome as agreed with the client. And obviously, it's very important to be very clear what the successful outcome is. And this is capped, this amount, at 100% of the benchmark fees. In other words, double what you would have otherwise got. And it can be either a no-win, no-fee agreement or a no-win, low-fee agreement. The second form is damages-based agreement, basically contingency fee agreement. The lawyer receives a payment, a DBA payment, only if the client obtains a financial benefit in the matter, and financial benefit is defined in the arbitration ordinance. This financial benefit, or rather the DBA payment, is calculated by reference to the financial benefit obtained by the client, but that is, for example, the percentage of damages awarded. It is capped at 50% of the client's financial benefit, and that is global. So if you have several groups of lawyers participating, the lawyers globally can't take more than 50%. I would say good luck getting 50%, but anyway, that's the figure that's in there. And then the third form of structure is a hybrid DBA. As its name suggests, this is similar to a DBA. The lawyer is to be paid a DBA payment only if the client receives a financial benefit, once again capped at 50%, but the client also agrees to pay the lawyer's fees, which are typically discounted for legal services rendered. There's quite a complicated provision dealing with what happens if there's no successful outcome and what amount of fees the lawyer can recover, but that was introduced because on this hybrid DBA structure, the lawyer would still get paid some amount. So third-party funding of arbitration reforms came in the arbitration ordinance was amended the law reform process finished in 2016 with a final report and draft legislation. The law was amended in 2017, but it took till February 2019 to draft the code, satisfy everybody's concerns and implement this. Has it taken off? Well, after the reforms came in, there have been the COVID and other things that happened, and so take-up anecdotally was slow. But apparently in the last year, parties are increasingly availing themselves of third-party funding for arbitration. And we certainly have quite a few third-party funders in Hong Kong. As for the OFSA, outcome-related fee structures agreements, in fact, anecdotally, I've been told by several colleagues, mainly I must say in big law, but a few Hong Kong firms, that they're already discussing the possibility of these kind of success and contingency fee structures with clients, and particularly solicitors, they're very open to it. However, of course, they're concerned about what happens if the case doesn't succeed, and that's why it's anticipated there'll be a need for after-the-event insurance. Currently, there's no after-the-event insurance product available in Hong Kong. My friends in big law tell me in London, for example, when they do these kinds of structures, they always have insurance, and they're confident that this kind of insurance is going to be available in Hong Kong. So that's another unintended or intended consequence of these reforms. And finally, third-party funders are exploring the use of OFSA. When we were doing the third-party funding of arbitration review, we would often have funders say to us, lawyers need to have skin in the game. Well, now, because of these most recent reforms, lawyers can have skin in the game. I apologise for going through so quickly these structures, but I hope that what I leave you with the sense of is it is now possible to have funding of arbitration in Hong Kong, whether by third-party funders or by lawyers, and that there is a fairly clear regime in each case. And if you have any questions, I'll be happy to answer them, but thank you very much, and I hope I kept the time, Eric. Thank you.
Oh, thanks, Kim. if anything, for the most impressive feat of being able to present on third-party funding and ORFS within the 15-minute period. And I can back up a little bit of Kim's statistics, because in 2022, we did see a significant number and a significant rise in funded disputes in respect of HKIAC matters. And we have heard also from the funders and from the firms that that trend looks to be continuing in 2023. So thank you, Kim, for that. One of the most important aspects of the international arbitration process is, of course, the enforcement of the award. And the question arises in many cases of, well, at the end of the day, after about 2 years of going through the dispute, are there going to be any assets for me to enforce against? And over the course of the last decade, we've seen an increase in the use of interim measures by arbitral tribunals and the use of court-ordered interim measures to help preserve the assets that are needed to enforce an award. Well, the problem is for those who are dealing with parties in China, because in China, the courts will not recognize interim measures which are ordered by an arbitral tribunal which is seated outside of mainland China. And so there's always been an issue of enforceability within mainland China from foreign-seated arbitral tribunals. That began to change in October 2019. Hong Kong entered into, and I have the full name here, I will use the abbreviated name and you will find out soon, that in 2019, Hong Kong entered into the arrangement concerning mutual assistance in court-ordered interim measures in aid of arbitral proceedings by the courts of the mainland and the Hong Kong Special Administrative Region. For the purpose of this session and my sanity, I will just refer to that as the interim measures arrangement. Now, the effect of that arrangement is essentially that Hong Kong became the first seat outside of mainland China where a Hong Kong-seated arbitral tribunal or Hong Kong arbitration could have a party go to a mainland Chinese court to seek a preservation order, either in terms of preservation of assets, evidence, or conduct. Macau, I should also mention, entered into a similar arrangement in 25th March 2022, but obviously for today we will focus on Hong Kong. Now, again, these three categories are for assets, which is the primary function of the arrangement, but we've also seen applications for preservations of evidence in order to preserve the process, and some applications for preservation of conduct. Now, when applying for interim measures before a mainland Chinese court, there are two requirements: that the arbitration be seated in Hong Kong, and that it be administered by a Hong Kong qualified institution, including HKIAC. And the process for that essentially is that you can start an arbitration and send us a request, or HKIAC request, ex parte, if needed, requesting what we call a letter of acceptance. And that letter of acceptance is essentially us certifying that this arbitration has been commenced and is on foot with the HKIAC. You can then take that letter of acceptance to a mainland Chinese court along with your supporting documents for the interim measure and obtain that measure from a mainland Chinese court. Now, this arrangement came into force on the 1st of October 2019, and in the several years since, we have seen great success in terms of the use of this arrangement. As of 28th of March 2023, we are seeing 91 applications for letters of acceptance from parties involved in arbitrations with HKIAC. 86 of those applications were for asset preservation orders, 2 were for evidence preservation orders, and 3 were for conduct preservation orders. The total amount that was requested in these letters of acceptance was about 23.8 billion RMB. That is about $3.5 billion US dollars. Now, those are all assets that, had the interim measures arrangement not been in place, would likely have dissipated by the time the arbitration had concluded. Now, HKIAC does not have complete information on all of the decisions made by the mainland courts, but we are aware of 66 decisions by mainland Chinese courts in relation to the IMA. 62 of those decisions in the mainland Chinese courts granted those preservation orders, granting a total of about 15.6 billion RMB, or about 2.3 billion US dollars. These applications were made to 34 different mainland courts, not only in Beijing and Shanghai, but in courts all around mainland China. And if you think that the use of the IMA was only for foreign applicants against mainland Chinese parties, well, that's what we thought at first as well, until we realized that while 19.8% of our applicants were mainland Chinese and 80% were foreign parties, when we looked at the respondents, only 64% of the respondents were mainland Chinese parties, and 35.7% of parties were actually foreign parties who had assets in mainland China. And the courts that we are aware of have taken an average time in mainland China of issuing an order within 19 days. So we have seen great success in terms of the use of the interim measures arrangement to help preserve assets, to help preserve the integrity of the arbitration, and help preserve the enforceability of the award. And I think this is where I want to now turn to Ben, because Ben, as an expert in relation to enforceability of arbitral awards, what do you see are some of the major trends that we're seeing in terms of enforceability?
Thank you, Eric. It's true that from an enforcement practitioner's perspective, Hong Kong has always been considered as a very high-value venue. And I'm going to start with the New York Convention, which is maybe the starting point. And although Hong Kong is not per se a party to the New York Convention, it's been applying the New York Convention since 1977, when the United Kingdom extended the territorial application of the convention. And that was, of course, continued in 1997 when not mainland China took over. And when you look at the case law rendered by Hong Kong courts in the past years, they've had some significant and very pro-enforcement decisions, one of which really attracted my attention many years ago, and even with Professor Gaillard when we discussed this, is the question of awards which have been set aside abroad or in case grounds for refusing to recognize an award are fulfilled. And there was a 94 decision from the Hong Kong High Court, the China Nanhai All Joint Service Corporation, which reminded that there was always discretion for courts to accept, to recognize an award, even if one of the grounds of Article 5 of the New York Convention are fulfilled. And this was, the explanation provided by the court at the time was very interesting. It said, I should exercise my discretion in favor of enforcement. So that in favor, that's the pro-enforcement approach taken by the courts. And this is an obvious case where the court can exercise its discretion to enforce the award, notwithstanding a ground of opposition in the New York Convention being made out. The conclusion is, in my judgment, quite consistent with the pro-enforcement bias of the convention and the pro-enforcement attitude of most enforcing courts around the world. So that was in '94, and you've seen recent application of the same discretion principle, which is very in line with the drafters of the New York Convention, which was in 2017 with the Dana Shipping, maybe 2016 Dana Shipping case, where an award had been set aside, and the question was whether or not that award could be recognized pending the continuance of the setting aside proceedings, there was an appeal on the setting aside, and the court decided that it should exercise discretion. Now, in that case, the court decided not to recognize the award, but not because it had been set aside abroad, but by looking at the award in itself and deciding by itself, according to its own interpretation, whether or not this award should be recognized. And it was really put in a very well-reasoned manner. And I think that this is something often that gets lost in the debate of awards being set aside. France is often seen as unique because France, as you know, does not have amongst its grounds to refuse recognition setting aside. But the rationale followed by the Hong Kong court, in my view, are very in line with what the drafters of the New York Convention did. And we're considering it's the discretion, it's for each court, for the place of recognition to decide whether or not they want to recognize an award, irrespective of the fact that it has been set aside. So, I've took this example, but there's many, of course, but there's a lot of case law in Hong Kong on the New York Convention. I think that it's one in the region and even in the world which has the most consistent approach in line with the spirit of the New York Convention. Now, the second aspect, which I've always found to be extremely interesting for Hong Kong, which may maybe not be the most well-known advantage of going and either choosing a seat in Hong Kong, but more importantly, enforcing in Hong Kong, is the fact that Hong Kong recognizes and enforces interim or emergency arbitrators awards. And this is something that may be a bit controversial in a number of jurisdictions. As you know, if you try to enforce the awards on the basis of the New York Convention, you need to prove that you have an award. And of course, it's always what is an award, which is not defined. And if you look at what the drafters of the New York Convention intended, there was many explanations, but one of which was a decision should be final and or settle, finally decide in full or in part the dispute. And that is in line with what you've seen in different jurisdictions. But then when you look at emergency arbitrators, decision and or orders and or awards, depending on the name, and if you look at interim measures, it is really done on a case-by-case basis in many jurisdictions. That's the case in France, it's the case in the United States, which have sometimes recognized emergency arbitrators awards, sometimes refused based on the fact that it did not finally decide this. There was cases in Ukraine, cases in Australia, but there lacks sometimes a bit of predictability as to what you understand for finally deciding an issue. If you grant conservatory measures, you finally decide the conservatory measures aspect of the dispute. But of course, it's temporary, so it can be then changed and will be changed, or it can be removed, revised, and or canceled by the arbitral tribunal. And so one of the ways to tackle this problem is to include legislation in this respect. And that's exactly what Hong Kong, Singapore, Spain more recently did. And I think it gives a lot of predictability. And if you look at Article 22, Section 22 of the Hong Kong Arbitration Ordinance, it says any emergency relief granted, and that is the most interesting part, whether in or outside Hong Kong, and I'll get back to that, by an emergency arbitrator under the relevant arbitration rules is enforceable in the same manner as an order or direction of the court that has the same effect, but only with the leave of the court. And you have a similar provision under Article 60 or 61 on interim measures. And if you, of course, it's limited for foreign-based arbitration. It's limited to a number of types of temporary injunctions that may be provided by the emergency arbitrator. But I think this is something that is even going further than the model law, which is also implemented in the Hong Kong Arbitration Ordinance. But I think that this is one of the main advantages, because that's has always been the debate. If you have interim measures, if you have emergency arbitrator awards and or orders, what's the point of it if you can't enforce it? Of course, that may have a deterrent effect on parties which would feel compelled to apply emergency arbitrators award, but I think that one of the key, I think in terms of efficiency, the fact that this is a temporary measure does not prevent the fact that it should be enforced while it can be enforced during the duration of the arbitration. And I've noticed in the caseload there's been a significant amount of interim awards and or emergency arbitrators decisions which have been enforced in Hong Kong, also in Singapore. This is a similar trend, but still I'll focus on Hong Kong. And I think that this is one of the best advantages of having a seat or enforcing in Hong Kong. Now, for the point the last reform with the interim measure agreement and the supplemental arrangement, I think that if you take the New York Convention the way it's applied, if you look at the interim measures and the way it's being enforced in Hong Kong, and you put that with the recent reform, you really have something that makes it, as a whole, very efficient. One of the first time I've looked at Hong Kong and looked at enforcement, I was a bit concerned at the beginning because I saw that there was concurrent jurisdiction between local courts and arbitral tribunals for granting interim measures. So the fact that the arbitral tribunal has the power to order interim measures doesn't prevent domestic courts, so Hong Kong courts, to also, in the course of the arbitration, not before the arbitration, the arbitral tribunal is constituted, which is often the case, such as in France and other jurisdictions. But you have a concrete jurisdiction throughout the arbitration. But what was very interesting is, first of all, that the law, Section 45 of the Hong Kong Arbitration Ordinance, provided that the court may decline to exercise this power. So it has the power to order interim measures in some circumstances, but it may decline to exercise this power if the interim award sought is currently the subject of arbitral proceedings, but it's not mandatory, it's a possibility. And more importantly, and that's the key point for me, was if it considers it more appropriate for the interim measure sought to be dealt by the arbitral tribunal. So give this form of deference to the arbitral tribunal. And when you look at case law, even recent case on that, you can see that this provision was applied with a lot of restriction. And courts in Hong Kong tend to defer to arbitral tribunals. So the concrete jurisdiction between domestic courts and arbitral tribunals should not be seen in a negative way. In that case, I wouldn't say that in other jurisdictions, because it's used in a very restrictive manner, because there is a deference to the arbitral tribunal, and sometimes some measures cannot be ordered by arbitral tribunal in the course of the arbitration, and that does not prevent, for efficiency purposes, domestic courts to do this. So then when you take that, and we take what everything I've said, and then we talk about the recent reform, and the fact that interim measures can be ordered before, pending, and more importantly for my purpose of enforcement, after the award has been rendered, in case it's an award that is based on an arbitral tribunal seated in Hong Kong, is really completes, I think, the regime. And you've seen more and more requests for interim measures just prior to enforcement. We know this is something that is very common in our jurisdiction, civil law jurisdiction, France, Belgium, Netherlands, Luxembourg, to order interim measures before starting recognition and enforcement. But this is something that is working very efficiently, I've heard. This is something that will continue to be efficient when the assets are in mainland China. And the fact that with the supplemental arrangement in 2020, you can also do simultaneous enforcement in Hong Kong and in China, really, for me, is one of the strengths of the recent trends I've been witnessing in Hong Kong.
Yeah, and Ben, I think you bring up a very important point, which is that the reciprocal arrangement between Hong Kong and mainland China in relation to enforcement of arbitral awards was just recently updated and does now allow for concurrent and parallel enforcement both in mainland China and in Hong Kong. Ben, if I can just sort of sum up what you've basically said, is that basically concerns and considerations of enforcement essentially start from day one. It start from the day that you're negotiating the arbitration agreement, because depending on where you choose to seat, you would be looking at potential set-asides, you'd be looking at the enforcement of emergency arbitral decisions, and you're looking at the potential availability of something like the interim measures arrangement, all of which eventually go towards the enforceability of the award. I mean, would that be accurate?
Yeah, it is accurate, but again, the fact that you don't think about the seat anymore in Hong Kong, at least you think of it, you open it to also awards being seated abroad, and you apply the same rules. This is purely an international, if I don't say a transnational approach to arbitration and enforcement. Yes.
Great. Well, thanks a lot, Ben. Let's... Let's move on shortly. You've heard us speak a lot about in terms of the changes to third-party funding, changes to the arbitration ordinance, changes to such as the interim measures arrangement. Robert, you've actually sat in arbitrations in Hong Kong, and you've had quite a lot of experience with Hong Kong matters, and also through the HKIAC. As an arbitrator who has sat in arbitrations around the world, what do you see as sort of been your experience with Hong Kong and sort of its suitability?
Well, thank you very much to GBS Disputes. Thank you to the HKIAC. And thank you, Eric, for the introduction. So yeah, by way of background, I spent 20 years in Hong Kong working primarily as counsel in big arbitrations. And 5 years ago, I relocated back to the UK for personal reasons. But I have continued to take appointments in Hong Kong, but also in many other seats around the world. So I'm able to compare how they function and how convenient they are and how effective they are. Hong Kong has many competitive advantages, and certainly as an arbitrator going to Hong Kong, you know you will be supported very strongly by the courts. Benjamin alluded to, in the context of enforcement of awards, the strong pro-enforcement bias. But more than that, the courts are very supportive of arbitration as a process. They won't interfere where they should not be interfering, but they will support. So as an arbitrator, that gives you a great degree of comfort. There are no horror stories. I mean, you hear some jurisdictions where arbitrators get themselves into a bit of difficulty and may have to rush to the airport to avoid arrest. Nothing like that has happened or will happen in Hong Kong. In terms of the judiciary, it's important to be aware that there is a specialist arbitration judge, Madam Mimi Chan, who has an arbitration background herself, so she really understands this space and is incredibly supportive of arbitration and arbitrators. More broadly, when one looks at the judiciary in Hong Kong, because obviously there have been suggestions about rule of law being eroded, that sort of thing. I think the acid test is the fact that you look at the Court of Final Appeal, the highest court in the land, and you see that there are still 10 foreign judges, retired foreign judges, who sit on the Court of Final Appeal. Now, there are very few jurisdictions in the world that can say that. So obviously, by having these very senior, highly experienced, foreign-trained judges, that is a counterbalance to any kind of political pressure or anything untoward that could happen in the legal process. So I still feel very comfortable saying that the rule of law in Hong Kong is strong, certainly in this space. In the arbitration space, I think it's undeniable. If you speak to some of the retired judges who continue to sit on the Court of Final Appeal, the foreign judges, they too will reinforce that. So they view it as their role and their place to remain on the Court of Final Appeal and to ensure that there is rule of law. And as I say, in the arbitration space, it's unquestioned. Now, in terms of more mundane matters, Hong Kong is incredibly convenient. Obviously, we've had a horrible blip with COVID, as the whole world has, and Hong Kong, I think, took that to an extreme, but we've come out of that, thankfully. So I travelled to Hong Kong most recently, late last year, and it was already fairly convenient. I went there for a big hearing. There were very limited restrictions in place. Since then, those restrictions have been removed. And when you go to Hong Kong, you're traveling to a place that has a modern, first-rate airport, excellent connections to many different parts of the region. It's convenient. There are lots and lots of good hotels. So just from a very basic sort of structural level, going there as a foreign arbitrator, it's a convenient place to go and to sit. In terms of fees, certainly the HKIAC fee scheme is very clear. So as an arbitrator, you will know that you will either be receiving scale fees based on the amount in dispute, or that you can apply an hourly rate. And there's a cap on that hourly rate of 6,500 Hong Kong dollars, which is equivalent to about 800 US dollars, which I would say is a reasonable cap and about appropriate. And certainly I found, sitting in Hong Kong, I've never had any fee issues. I mean, the institutions there are very good about getting money and ensuring arbitrators get paid. And there's a lot of transparency. You know what you're going to get paid. And of course, I'm speaking from the perspective of an arbitrator. The people who really matter are the users, and they are choosing Hong Kong in droves. So Hong Kong remains, I believe, the third, in the top 3 at least, most popular seats in the world, which is really the acid test. Now, as an arbitrator, often you'll want to have a tribunal secretary. The HKIAC certainly offers a very good tribunal secretary service. They have a pool of talented young individuals who can assist you on a case. And the fees are very reasonable. So they'll start as low as 1,000 Hong Kong dollars an hour. So, I mean, that is delivering cost efficiency for the parties. And it also means that you, as arbitrator, are getting the right kind of support, and you can feel comfortable about that. And in terms of hearing venues, I mean, the HKIAC itself has premier hearing facilities. If you go there, incredibly convenient. I mean, they have a library there. You can work there when you need to. And the hearing facilities are excellent, but I mean also there are lots of law firms there with top quality facilities. So I have done hearings in law firms, in law firm offices there, which that has been very effective. The law is up to date. So the arbitration ordinance was enacted. The current arbitration ordinance was enacted in 2011. Follows very closely the Untitled Model Law 2006 edition, and offers a wide range of interim relief, complete protection on confidentiality, and an opt-in mechanism to appeal awards based on a question of law. And I should say that none of my awards have ever been appealed on a question of law or otherwise. So I found the parties in Hong Kong to really understand that the value of arbitration, one of the values of arbitration is finality, and to accept the concept of finality. And as Benjamin alluded to, I mean, the ultimate acid test is whether you can enforce an award. And there's no doubt that the Hong Kong courts have been really excellent and strong in enforcing awards, both Hong Kong awards and foreign awards. So for myself as an arbitrator, I love going to Hong Kong. I'm very happy that the COVID restrictions have gone. I'm looking forward to getting out there again soon. And it's just a very comfortable, easy, sound and safe place to be sitting as an arbitrator. So thank you.
Eric.
Thanks a lot, Robert. It's funny you mentioned Mimi Chan as head of the specialist list, because I think that recently we'd heard comments concerning about whether or not there would be pressure for a judge to change their views based on political considerations. And I can say that previously, prior to my career at HKIAC, I was a barrister. And speaking as someone who has appeared before Mimi Chan, trying to convince her to do something that she doesn't want to do, good luck with that. She is fiercely, fiercely independent. Wesley, do you have a comment on that?
No, I was actually just going to supplement what Robert said. I think that to add some statistics to what Robert said, in terms of enforcement and Hong Kong courts' track record for enforcement of awards, publicly available, released by the DOJ, certainly in the past few years, certainly in 2017, 2018, no awards were actually refused enforcement in Hong Kong. And I think that's an important statistic. And I think that we've also broadly looked, while at the HKC, as to the incidence of when an award will be set aside by Mimi. And that number is a very low percentage of number of cases. So it's also quite supportive in that regard. And I think that the other part of enforcement that's also really important for many in the room, perhaps, who may be dealing with PRC parties, and certainly, Eric, you can update me in relation to the latest statistics in this regard, but when it comes to Hong Kong seated awards that are enforced in the mainland under the 1990 arrangement, which Mohamed had updated in the 2021, HKC's track record is tried and tested. In 20 plus years, it is only known that 3 awards from the HKC have been refused enforcement by PRC courts. And that's an excellent track record. And I think that's very important for parties, certainly in a foreign context, that are looking to choose Hong Kong, for example, as a seat, to know that there's that comfort in relation to the 1990 arrangement for the enforcement of awards. But
No, I mean, Wesley, I think those numbers are still accurate as of today. And obviously, when we talk about enforcement of awards, again, this starts from day one. And in terms of the scheme of the interim measures arrangement in conjunction with the reciprocal arrangement between Hong Kong and mainland China, if you are doing business with a party in mainland China, really Hong Kong becomes the primary choice because of just the structure of the regime and the unique advantages that it has. While we're on that, on you, Wesley, now that you've spoken up, let's talk a little bit about your experience with previous industries. I think when you were at HKIAC, and even up until recently, I think we primarily saw HKIAC deal with disputes around sort of commercial sale of goods transactions as sort of our #1 industry sector. But we're seeing times starting to change now. We are, for example, in 2021, only about 16.2% of our disputes dealt with banking and financial services. In 2022, that jumped to 36.9%. That leapfrogged over the industries of commercial sale of goods and those sorts of transactions. A lot of that came down to developments in digital assets, developments in fintech, developments in cryptocurrency, which Hong Kong has a lot of companies which run through, a lot of exchanges that run through Hong Kong, being a financial hub. And so we started to see a change and shift in terms of the types of disputes that HKIAC was seeing, particularly in relation to having to find arbitrators, having to find those who had knowledge and experience with cryptocurrency and crypto disputes, as well as the procedures that would need to be put in place in respect of these sorts of disputes. Now, Wesley, I'm going to maybe turn this over to you now. You have had experience with these sorts of cryptocurrency disputes. So it'd be good to get, I think, a view from you as to what sort of considerations parties have to have when dealing with essentially a new type of asset.
Thank you very much, Eric, and thank you very much to GBS Disputes and the HKIAC for having me here today, especially in this excellent venue. I think that if I take a step back, and certainly as you were talking about, Eric, is to really look at what are we talking about when we talk about digital asset disputes. I think many will have seen or will have heard about FTX and Silicon Valley Bank and everything that sort of, and terminology such as the crypto winter has certainly hit the headlines for many of us. And certainly, that's more the recent headline grabbing sort of attention. I think the disputes that probably are rising for the HKIAC actually even go back a year before that, when there was a major drop, certainly in the crypto markets back in May 2021. That's certainly where many of us will have seen the activity as counsel in cases, and certainly as arbitrators as well. But I think that you've also touched upon an important distinction between what are we talking about in terms of digital assets and digital currency and crypto or crypto-related disputes. I think there's one that certainly plays to Hong Kong's strengths as an international financial center alongside New York, London, and other cities in the world. And it's not unusual for Hong Kong to sort of been a centerpiece for a lot of finance-related institutions, finance-related sector areas. And certainly as we've seen, and certainly in terms of my own cases, there are a lot of disputes that are FS, financial sector-related disputes. And the uniqueness of this, or the rise in which the digital assets becoming the underlying asset in relation to these disputes. So there is sort of a large number of these disputes that are arising in relation to the financial sector. I think the other area of crypto-related disputes or crypto asset-related disputes, which I think is something we can come on to during the coffee break, but is an area related to constructs in the metaverse. And I think that's a sort of a different burgeoning area that's gaining a lot of attention as to sort of how disputes were resolved in the metaverse in terms of enforceability, the jurisdiction within that, and issues regarding privity of contract and how exactly you having commercial dispute resolved in the metaverse. Turning back to in terms of finance-related disputes, I think that for those who've had experience in this area, including myself, there is a little bit that is quite familiar in the fact that they do surround very familiar financial and instruments or familiar commercial constructs. So one of the disputes I handled just last year was very similar to and is the master agreement. There was a framework agreement entered into between the parties that provided for HKIAC arbitration, and then there were a series of various term sheets that were their own separate agreements that arose under the framework agreement, and the parties were fighting over liquidation levels in the case, which is, again, not something that those who do a lot of banking and finance disputes would be unfamiliar with. So that's certainly, and we've seen certainly in the news and the headlines that various platforms, and I guess you would call them prop traders in relation to the crypto markets, are bringing disputes along this area against very large platforms. One that's been publicly named in the news is in relation to CoinFlex. They very publicly indicated they were bringing arbitration in Hong Kong, and their base of operations is primarily in Hong Kong, as well as other crypto-related platforms are also sort of based in Hong Kong, like OSL and others. So it's not unusual to sort of find this sort of type of disputes, and because Hong Kong is already home to a lot of counsel and arbitrators who are very familiar with finance-related disputes, you do see that it's a very conducive environment for both the HKIAC as well as the legal market to sort of handle these types of suits. So it's not surprising, Eric, that you're seeing this rise in disputes. And I think that one thing that even preceded, which is sort of to the credit of HKIAC, that precedes the rise in crypto disputes was actually the fact that there is a specialist panel of arbitrators that was established in 2017 devoted to finance-related disputes. So, you know, it doesn't have a magical name. It is a panel of arbitrators in finance-related disputes. And it does include crossover with many arbitrators who also sit on the prime list, another area based in the Netherlands that focuses on finance-related disputes. So you have a lot of features that make it beneficial to having, in a roster of arbitrators that makes it beneficial to having your disputes resolved in this space. I think the other area, and certainly Eric and I can discuss more, are perhaps talking about some of the features you have in the HKIAC rules that make it both cost-effective, time-efficient, and as well as dealing with multilateral or multi-contract and multi-party type disputes. And of course, Eric, you can probably highlight a few of these, but I'm thinking of issues like Article 28, which relates to consolidation, and Article 29, which allows for a single arbitration under multiple contracts. And just in my example, for example, we did have, it is the type master agreement as the framework agreement, but as I said, there were individual agreements that came in the form of loan term sheets, and they could have been regarded as sort of separate regimes unto themselves, to which you could have brought multiple cases under each term sheet, and then you would have multiple cases. And you do, in that case, certainly as claimant, want to be able to bring your arbitration as one dispute rather than having to file maybe multiple disputes and sort of the implications that comes with. But Eric, maybe, I don't know if you wanted to highlight some of those specific features that, and perhaps the role of the Proceedings Committee in that regard.
Yeah, I think that's a very keen observation, Wesley. And when the HKIAC rules were released in 2018, we had some of the most advanced rules and provisions in relation to complex arbitrations and multi-party arbitrations, everything stemming from joinder and consolidation, but also in relation to just being able to commence a dispute or commence a matter under multiple contracts under Article 29. And then when all of those provisions fail, we also had provisions under Article 30 of the HKIAC rules, which allow for concurrent proceedings. So even in situations where, example, the parties are unable to consolidate or the arbitration agreements are not considered compatible, and so neither consolidation nor Article 29 are applicable, there is still an opportunity and option for the rules for the arbitrator to conduct proceedings in a manner concurrently that would allow for an efficient resolution of the dispute. Now, Wesley, you also had some experience with our expedited proceedings, and especially when we're talking about the volatility of sometimes a digital asset. And sometimes by the time you complete a 12 to 14 month process in terms of arbitration, well, that asset may be completely devalued, right? So is there a need or importance for expedited or perhaps even super expedited procedures in relation to arbitration?
I think that's an interesting point. So those who are familiar with the HKIAC rules, Article 42 under the 2018 version provides for the ability to apply for expedited procedure. And obviously the key feature of the expedited procedure is the ability for an award to be rendered within 6 months from when the case file is handed over to the tribunal. And it has many of the key features you would find under other institutional rules, whether it be the SIEC or the ICC. So in that sense, it is one of the best practices. The question is in terms of the two thresholds in which you would make an application under Article 42, the first of which would necessarily be under the monetary threshold. So that application, and the way this is set up on the HKIAC rules is that it is a fee threshold of which is published on the HKIAC website, which allows flexibility for HKIAC to change it rather than having to revise the rules every time they want to change that. And that's currently set at 25 million Hong Kong dollars. So a dispute under that amount, which is roughly 3 million US, you can then make an application as a claimant for the expedited procedure to apply to your arbitration. The other threshold, and this is speaking to your point, Eric, is in relation to the exceptional urgency limb to which the HKIAC can make a decision to apply the expedited procedure, even if the monetary threshold is not met. And in this case, at least during my time, the first case, the HKC has granted this under the exceptional urgency basis, and it did so in 2018. In that case, it was extremely urgent but that was more in relation to a financing arrangement in relation to an M&A transaction to which the parties needed a decision within 3 months. So it was done on an expedited basis. But I think the other thing about this, and this speaks to the credit of the Secretariat at the HKC and the powers of the institution itself, is the ability to amend its timelines and to meet the expectations of the parties in relation to making a quick decision. Not only making a quick decision in relation to the application for expedited procedure to apply, but also looking to the timelines to which the parties will file submissions before they make that application. So in 2018, when we made the decision to grant exceptional urgency, the claimant filed the notice of arbitration, and because both sides were represented by very large, sophisticated big law firms, we were able to shorten the timeline for when the respondent was meant to file the response or the answer to the notice of arbitration, which then allowed us then to proceed very quickly to make a decision in relation to the expedited procedure application. The other benefit in terms of the way that HKC is structured in terms of how it makes decision is that many will be familiar, there are two very important standing committees that sit within the structure of HKC. The first of which is the Proceedings Committee, which deals with a lot of the procedure issues like the expedited procedure application, applications for consolidation and joinder before the constitution of the tribunal. The other, which is the Appointments Committee, which its name suggests, deals with appointments of arbitrators, termination of arbitrators, and so forth. Because the institution is quite agile in terms of how it goes up, it makes applications or recommendations to the Proceedings Committee. That's usually done electronically by email, and usually allows the institution to make these decisions very quickly, certainly within a day if possible. So that's very important if you're dealing with an asset issue or you're dealing with a crypto dispute where you really do need to, as we're saying, the fast-paced nature of some of the digital asset world, it does hinge in relation to sort of these issues. I think the other thing, which is also pointing to what Robert had mentioned, is in relation to sort of the fee structuring. So as some of us will have seen, and I've certainly seen this in my own practice, is that some of these crypto asset disputes are actually not very large. And they can be within the $1 to $2 million US mark or less, for example, which makes it very difficult for parties to engage counsel, but also then to bring cases forward because you've got issues in relation to, well, how much is the arbitrator going to cost? Is that going to add to it? Is the number of arbitrators? And so I think that the fee cap that Robert referred to in terms of the highest amount that an arbitrator can apply or can charge under Schedule 2 of the HKC rules is really important. I think it's also important to note that the default under the HKC rules actually is an hourly rate. The ad valorem that Robert referred to applies only when the parties actually agree to an ad valorem basis for the compensation of arbitrators. And typically, by and large, most cases at the HKC are actually under Schedule 2 on an hourly rate basis.
Thanks a lot, Wesley, for that keen overview of crypto disputes and sort of the procedural considerations that are necessary there. I'm going to turn this over now to Robert and Mohamed to sort of comment on this. You've now seen or heard things in relation to third-party funding and outcome-related fee arrangements in relation to interim measures arrangements and the ability to enforce awards. And I'd like to turn this over to both the two of you to comment on what you've heard. And does this change any sort of the equations in terms of determining Hong Kongers or the suitability or attractiveness for foreign parties that are dealing either with China or, for other countries such as Russia?
Well, I don't think it changes anything. I think it reinforces the message. I mean, Hong Kong has been for quite a while now and continues to be the obvious choice for foreign entities doing big investment in China. When I was practicing as a lawyer in Hong Kong, that was the bulk of my practice. And if I was still practicing in Hong Kong as a lawyer, I'm sure it would still be the bulk of my practice. So there's no doubt that Hong Kong is the seat for resolving China-related disputes. Now, of course, other seats are taking some of the work, but Hong Kong continues to get a lot of it, the bulk of it. And there are good reasons for that. I mean, in Hong Kong, you have lots of lawyers and other professionals who are bilingual. that can't be overstated, the importance of that. There are lots of people who have, for many years, been dealing with Chinese disputes, whether they're bilingual or not. That's been the real meat of their practice. So there are lots of people there to really help and understand and have a history of dealing with Chinese disputes. And we heard about the arrangement on interim measures. Again, the importance of that cannot be overstated. The fact that you can go to a PRC court and obtain interim measures in aid of a Hong Kong arbitration is absolutely crucial. It gives the party the ability to enforce at the end of the day, the confidence that it will be able to enforce, and that is the critical thing. They're not doing it for the pleasure of getting a Pyrrhic victory. They're doing it to recover assets and recover money, and having that ability to get interim measures from PRC court is massive. And then, of course, there's the arrangement on enforcement of awards, final awards, which we heard alluded to as well. And of course, that arrangement mirrors very closely the New York Convention. But I would say it's in many ways better because Hong Kong is part of China. You're getting the best of both worlds. So you're not going to be subject to any political risk if you were to get a foreign arbitral award and you're trying to enforce it in China and there's some big political issue that comes into play. That won't be there. You're avoiding that risk. And actually, you have an institution in the form of the HKIAC, which is very, very experienced in monitoring enforcement of its awards in mainland China and has had a very good success rate. So for those reasons, I think Hong Kong remains and will continue to remain the seat of choice for resolving these big China-related disputes.
Yeah, perhaps maybe I'd jump here, and thanks, Eric, for the kind introduction, but perhaps I'd jump in here on sort of a butterfly effect that happened as a result of the Russian invasion of Ukraine. As always with these things, there is sort of it's not an intended consequence, but it just happens that way, and that's sort of the internationalization of previously regional seats. So Hong Kong is an obvious one of those, but before we get into it, let's just sort of define the scope of the issue. First, who are the concerned parties? What are the concerned transactions? And there you're talking about two streams. One stream would be deals between Russian entities and European entities or American entities, because these are still ongoing. Not all sectors are sanctioned. And then you have deals between Russian or Russian-related parties and other parts of the world that do not have sanctions against Russia. And for both of these types of deals that are being negotiated over the past 14 months, because that sort of activity has not stopped, seats of arbitration had to be found, institutions have to be chosen, and applicable laws had to be chosen. And what were previously, quote-unquote, non-region specific, so universal, if you will, seats like Paris, London, Geneva, perhaps The Hague, are suddenly less appealing to both parties, and for political considerations, or at least perceived political neutrality considerations, or proper regulatory sanctions reasons. And that same applies for what used to be the previous home of these disputes, of Stockholm and so on. So what is the scope, then, the material scope of the issue? So they have the seat, this choice on the seat, the discussion on the seat, which becomes very difficult in these negotiations, the discussion on institution, and bizarrely, because these two, one can understand why, because the seat, sanctions might very much disrupt that and disrupt the ability to conduct the arbitration. The institution equally, the sanctions may impact the ability of the institution to administer the arbitration. The applicable law to the contract, much less so, and I think it just comes in, but you see it a lot. We've seen it in our practice in negotiating sort of energy deals, where Russian parties would tend to say, no, I don't want a deal that would have normally been subject to English law before, or to French law, or to some other law. No, I want some other neutral law. But It's the contract law, it's not the sanctions regime, but there is a bit of confusion on that as well. But let me focus on the two that are more interesting, which is the institution and the seat. Now, some institutions, like the HKIAC, have the benefit of being in a jurisdiction that does not have sanctions. So it becomes an obvious choice. Others have dealt with that by getting exemptions. So the LCIA, whose a good part of their business was Russian, British, sort of Russian-European disputes, have applied for and the process of getting a license allowing them to administer these things. But there is a limit there. There is a sort of reality check limit. We were discussing it with Wesley earlier. Money. You may have all the regulatory permissions you have. If you don't have a banking system you can rely on to process fees, to pay money, then you're a little stuck. Now, some institutions like HKIAC have a policy on sanctions, even from before all of that, that allows payment in different currencies if there is an issue with sanctions. But that's not always, sometimes the problem is much more fundamental than the currency in which you pay. Sometimes it's just access to the whole network. And we've seen that obviously with the current slew of Russian sanctions. Now, going on to the seat is even more sort of complex an issue. And what is not deniable, and you see that quite a bit, is that two big seats that have benefited quite significantly in contracts, sort of choice of seats are Hong Kong and Dubai. These are both seats that previously were leading seats in the regional space, but now they're being chosen for disputes and for contracts that have absolutely nothing to do with Asia or with the Middle East or what have you, just because that's the seat on which, let's say, a Russian and a European party can agree, or a Russian and a Latin American or Middle Eastern party can agree, so that go to Hong Kong. And that's, so the phenomenon is clearly here in terms of, now I've looked at the numbers in terms of arbitrations. Obviously, the uptick is not there yet because it's all very recent. But in terms of deals that we see and that we've been negotiating, you see it quite clearly. So the phenomenon is here. The question that remains is, what to, for how long? And because of all the sort of features we've been discussing all morning, the idea is, well, as with everything in history, there are always accidents that lead to certain things, and the question then, whether they become stable or not, will depend on how you benefit from the accident. And here, these features may allow Hong Kong to consolidate on that sort of incoming flow of work to make it more of a lasting impact as opposed to a conjuncture-based phenomenon. Then the last one, and that's a question I'll leave you with rather than give an answer to, is one sort of the solution that practitioners have come to, which is choose a new universal seat rather than go to the typical universal seats. Choose a new universal seat for these stream of disputes, and they're not insignificant, neither in terms of number nor in terms of amounts. They tend to be in the energy space, they tend to be rather large deals, they tend to be rather long-term deals. Well, will the sanctions make their comeback? And that's sort of the second reality check. So for the institution, it was the cash. For the seat, then it becomes the legal question of how long will the law of either of these seats, be Dubai or Hong Kong, resist the temptation, quote unquote, of recognizing or not these sanctions through the local conception of international public policy. Because ultimately, in every seat, that would always be there. Now, these are unilateral sanctions. The likelihood of that seems rather remote, and I speak under the control of all of those around me. But unlike, say, the Iranian US sanctions, which are really unilateral, really specific, and only the US, and are even countered by the EU, the Russian sanctions, how they're headed and how they're stayed for now at least, they're a little more universal. They're starting to become a lot more broad, a lot more accepted. Question then becomes, will there be an argument that they're distinguishable and that they might become part of sort of local international public policy? That will depend on, I think, political events and how they unfold. It will depend on political pressure in all likelihood. It will also depend on the practicalities, and that will tie back to the money issue, is that if the financial pressure is hard enough, if the grip of the financial sector and the sanctions through there are long-standing enough, maybe or maybe not, that may impact things. Thank you.
Thank you very much, Mohamed and Robert, for those very insightful comments, particularly in respect of the questions of public policy in Hong Kong and Dubai as a seat for Russian disputes. I do want to comment that you say the uptick is not there yet. It wasn't there yet in 2022, and obviously we're not able to release 2023 statistics yet, but I can say that that wave is here.
That was quick.
It was quick, yeah. I think at this point we're going to open the floor to some questions. If you have a question, please raise your hand. I see Alice in the back and then one in the front. And if you have a question from the online audience, please put it in the chat and it will get transferred up to us. So sorry, if we can take it up and into Alice first.
Well, first of all, thanks for the great panel. It was really great. So I'm Alice Meister. I'm actually based in Vienna, and besides my private practice, I'm also on the board of senior advisors to a third-party funder, the Valion. And we've looked into the funding regulations of Hong Kong. So I have two questions for Kim. Yeah, thanks for the great overview. I'm just, when I looked at the arbitration mediation legislation ordinance 2017, yeah, right, I understood that the provisions regarding third-party funding of arbitrations are in place, but the provisions of third-party funding for mediation proceedings have been deferred. So would like to have your view or your update on that. And how shall third-party funders deal now with funding opportunities in ARP-made or made-ARP proceedings? That was my question.
Thank you very much for that question. And it goes to a very important part of these reforms. The third-party funding is available for mediation that is associated with arbitration under the arbitration ordinance. And this gets into the next point, which is that we also have a separate mediation ordinance which covers non-arbitration related mediation. And you are correct that third-party funding has not been extended to that. And may I say that my understanding is the reason it took from mid-2017 to early February 2019 for the whole package to be implemented was because of a discussion about whether these reforms would extend to mediation generally, not just in association with arbitration. And the outcome was, at the time, the community wasn't ready for it, so the reforms were limited to mediation under the arbitration ordinance. And so parties can structure their agreements to encompass mediation, and then they'll, as well as arbitration, then they can get the benefit of third-party funding. And your second question concerned funding opportunities. Sorry, what was that question? May I just clarify that?
I think you answered that question in your first remark. So if the mediation is related to arbitration, that's covered with the current provisions. So the sole mediations are not fundable yet.
That's right. And from the public policy angle, I think there was a general concern that mediation for civil disputes, grassroots disputes, were not ripe yet, were not fit for this kind of commercialisation of practice. Remember that legal cultural issue that we have in Hong Kong. But if it's mediation that's structured to go with arbitration, you can get third-party funding.
Thanks.
And then up front.
Hi, I'm Christophe Duguay. I thank all panelists for their views, and I apologize my comment and questions direct to Wesley Peng. In my experience of cryptocurrency dispute as an arbitrator, I concur with your view that there is no magic in that, so long as you have some experience in financing matters. And apart from the case where the dispute would be about something very technical, as I've seen alleged by the parties, but not pleaded by the parties for, a technical glitch in the exchange. What I've seen is that the serious players tend to include arbitration agreements in their terms and conditions, and especially Hong Kong is one of the favorite places, and some players, and not the least players, such as Binance, switched places. You can see over time they selected Singapore, then ICC Paris, and then Hong Kong. And one of the peculiarities of those agreements is that, you just click on a box on the internet, on your screen, and you accept the terms and conditions, and you also accept that they can change. And the latest version that applies is the one that is available. And so long as you continue your transactions, you are supposed to accept. So one thing that could occur is that one exchange you're dealing with elects for Singapore on day one and then switch to local courts or another institution. So that's one of the issues I've identified as a possible difficulty. And in fact, in my experience, and that would be my question for you, it seems to me that in fact in those crypto disputes we may face more procedural issues than substantive issues. And one of those, and I will stop there, is that in some of the terms and conditions you have a counterparty which is a named company with an address, so you know who could be your opponent. In other terms and conditions it states that you're dealing with name of the exchange and all of the other companies that are involved in the transactions you're about to perform with them. But it's for you as claimant to identify which of those companies, not non-name companies, is responsible for whatever you have to claim. So that could be a major difficulty which I have faced with the claimants that named 3 out of 30 plus companies, but didn't select the right one. So that's my question. Did you face this kind of issues?
I haven't had. I face this issue in an advisory context in terms of how best to approach it from a claimant's perspective, and I think that it is certainly an issue in terms of the sometimes evolving nature and some. I think part of it, which may be cultural, with the advent of digital and crypto, is the decentralized nature of it, and it's more than just a business and commercial decision. But in some respects, you may have seen this as well, there's a big push to move away in terms of where they're incorporated, how they set themselves up, and how they've moved away from perhaps maybe, these are the platforms themselves, and not wanting to be in the traditional areas. So in my case, I've dealt with a lot in Estonia and Indonesia, and certainly all of them are incorporated offshore, either in the Cayman or the BVI, to the ones that you can identify. So it then becomes sort of a spider network of exactly how you track down who the respondent is and which entity you are actually, in fact, suing if you are bringing the arbitration. And I suspect you're raising this in terms, as you said, some of the procedural issues. There's also issues in terms of communicating to the other side, to the extent that they're actually going to participate in the dispute, and how you then, which also has trickle-down effect in terms of when you get a favorable award, the ability then to enforce that award against the correct entity, assuming it doesn't get set aside at the set-aside stage. So I think that's an important part. I think the other thing that you've also highlighted, which, forgive me, I didn't get to raise during my presentation, is exactly that point on the T's and C's and the evolving nature of the T's and C's. But I think you will have also seen an interesting aspect of T's and C's when it comes to some of these platforms, is an express exclusion of anything related to class arbitration. And I think that's an important part in terms of both access to justice for some of these claimants that are suffering grievances with some of the platforms is the inability to collectively bring disputes against a particular platform. Now, we've all dealt with the issues in terms of more broadly in the past few years in terms of mass arbitration and class arbitration, but you can see in this context where your dispute is of a certain value that it can be prohibitively expensive as a claimant party, not the council, claimant party, to want to bring in an arbitration on your own against a very large platform that's going to get a very big firm to face off with you and will drive you down procedurally to make it expensive. I think the other thing, this also probably brings into what Kim was saying in relation to Hong Kong having third-party funding now available and ORFs in terms of that allowing that may allow for a little bit more of that. And then another development that others may be familiar with, which is still being explored in Hong Kong, is the introduction of class disputes in Hong Kong legislation, but that's still just very nascent in terms of what the DOJ is doing. I know I've been a part of the consultation process launched by the DOJ, but it's been a couple of years now since I've been asked to provide any further feedback. So these all go hand in hand, because if you have 100 of these individual investors who don't have claims larger than $500,000 or even $1 million, but they're all individual claims against one large platform, if you're the large platform and you can't consolidate under Article 28, or you can't bring one arbitration because they're all different parties and they're all not related, then you as the exchange are very easily being able to fight against each individual because you don't have the benefit of a class. Now, if there was a class plus a contingency fee of arrangement, then I think that would level the playing field with some of these exchanges.
If I may just add
very quickly, yes.
Very quickly, just on that point, I've seen, and I don't remember the name of the platform, but one did provide for what they call batch arbitration. So they would, it's not a class, but they would take 100 claimants represented by the same firm and treat that in one single arbitration, and then another batch and so forth. So some platforms already thought about that. Thank you.
Thank you very much. I'm afraid that is all the time that we have today. If you do have other questions, I'm sure many of the panelists would be very happy to discuss those with you after the session today. So with that, it just leaves me to conclude that over the course of the past several years, you've seen significant developments in Hong Kong in respect of its arbitration law, in respect of the Lex Arbitri and the arbitration ordinance which governs these disputes, as well as HKIAC's procedures and our practices in respect of adapting to changing industry landscapes and changing trends in international arbitration. Thank you to Gaillard, Banifatemi, Shelbaya Disputes again for arranging this beautiful venue for this morning, for arranging the breakfast, and for being such a wonderful partner in terms of making all of us feel so welcome here in Paris over the course of this week. Particularly thanks very much to Ilyas Banifatemi, to Mohamed Shelbaya, to Benjamin Siino, Otman Benlafki, for helping host us and make all of these arrangements. I leave with two final reminders. If you are interested in coming to Hong Kong, we have two major events coming up. We have the Hong Kong Arbitration Week, which is coming up in 16th to 20 October of this year, which we hope to see many of you at. I know many of you may not be wanting to think of another arbitration week after the current week, but it is several months away, so we hope to see you there. And if we don't see you in October, we definitely hope to see you at the ICA 2024 conference taking place from the 5th to the 8th of May in 2024. HKIAC being the host organization, we are doing our utmost best to make sure that anybody who comes to the conference in May will have a unique and unforgettable experience. So with that, thank you very much for attending this morning. A bientôt.